Namaskar and welcome to Sansad Television. I am Vishal Dahiya and you're watching our show Perspective, where we bring you detailed analysis of key national and international issues. Today we're going to talk about the Maharashtra political crisis. There are lots of twists and turns which are coming along the way in the past few days and today as well. Maharashtra Governor Bhagat Singh Koshyari has asked the Maharashtra Legislature Secretary to hold a floor test of Chief Minister Uddhav Thackeray-led Maha Vikas Aghadi, that is MVA government, at 11 a.m. on 30th of June. This comes amid the rebellion in the ruling Shiv Sena by Senior Minister Eknath Shinde, who, along with the other rebel MLAs, were camping in Guwahati since last week with the majority of party legislators and several independent MLAs as well. Now, this rebellion within Shiv Sena has pushed the state government led by Thackeray into a serious political crisis. BJP leader Devendra Fadnavis, meanwhile, met the governor on 28 June and requested him to ask the Shiv Sena-NCP-Congress coalition government in the state to prove its majority in the assembly, claiming that the ruling dispensation seemed to be in a minority with a rebellion by a majority of Shiv Sena MLAs. Meanwhile, Shiv Sena approached the Supreme Court on Wednesday against governor's decision to hold a floor test in the assembly on 30th June. The arguments in the Supreme Court went on for almost 3 hours and the court has reserved its judgment, which will be revealed at around 9 p.m. today. In the ruling coalition, Shiv Sena has 55 MLAs in the assembly, NCP has 53, Congress has 44, along with some other smaller parties and independents supporting the government, while the main opposition, BJP, has 106 MLAs. Out of the 55 Shiv Sena MLAs, rebel leader Eknath Shinde claims to have the support of around 38 or 39 MLAs of the party, along with approximately 9 to 10 independents. In the next 25 odd minutes, we'll discuss and analyze all the aspects of this current political situation in Maharashtra and some legal and constitutional angles and aspects of this as well. And for more on this, we're joined by a distinguished panel of experts. Let me first introduce them to you, beginning with, we have with us in the studio Mr. Kapil Sakla. He's an advocate in Supreme Court, keeps a close watch on all such interesting developments in the constitutional domain as well. We're also joined by Mr. Chakshu Roy. He's the head of outreach in PRS, and Mr. Sanjay Jog, a senior journalist from Mumbai, is also joining us. Welcome, all of you gentlemen. I'll start with you, Advocate Sakla, because there are a lot of arguments and counter-arguments which went on in the Supreme Court for almost 3 hours between all the parties which were represented in this particular case. And the court has now reserved 9 p.m. as the time for its judgment on this. Let's look at some important aspects and important angles. What is it in terms of arguments and counter-arguments and the basis which have been given by both sides?
All right. Thank you for calling me. It's a very interesting thing, anti-defection laws. Just to give the little background, they started in 1960s. There was a lot of rampant defection. The American term is horse trading. And in 1967, there was a Mr. Gayalal who shifted parties, I think, thrice in a day, coming up with the term Ayaram Gayaram. In 1980s or 1985, the anti-defection law came into being, so to say. And in 2003 odd, there was an amendment. And it's a very interesting turn of events because the 2003, the final of it said that where there is two-third majority, so the magic word is two-third majority, whosoever has two-third majority basically rules that day, which basically means that he is in majority, he can call the shot, he can either say that we are merging with the other party, he could say that we are taking over the party because there is no confidence in the ruling party as in, or the leadership as on now, or they could start their own party as well. So, as far as anti-defection or the 10th schedule is concerned, which was argued today, is this, that if a member defects, he shall be disqualified. However, if more than two-third defect at the same time, then the rule of disqualification or the bar of 10th schedule will not affect them, would be null and void. So, this is what it is. Now, the Shinte camp has more than two-third majority, and that's what they're claiming. Now, the question arose whether the deputy speaker can disqualify them in terms of the teeth of the 10th schedule. Saying that because you have now jumped ship, you're not listening to the whip, you're not listening to your leader, you're saying that we are no longer a part of the party in concern, you're disqualified, which means that they cannot vote. So there could be no confidence or no confidence vote. Now this argument was actually fallacious for two reasons, and this is what was argued today. One, where there is patently two-third majority, even if one of the MLAs of the ruling party says that there is a disqualification, whether it's in the teeth of the 10th schedule and a person needs to be disqualified, then that person has to prove the majority. And at least 7 days time is given, which was not given by the Deputy Speaker, and the Honorable Supreme Court came into protection. Or the people who now enjoy the majority, which is 2/3 and more, can move to the Deputy Speaker and say, listen, we are in majority, please listen to us. Now the question of disqualification, the power of the Deputy Speaker vis-a-vis the floor test that was asked for the Governor was being argued today.
So the larger question, which is to be decided by the Supreme Court, is that what takes precedence, the floor test or the disqualification of the MLAs? That's what is which we'll get to hear at 9 p.m. We have Chakshu with us. Chakshu, your views on this, because this is not the first such instance. There have been previous such cases as well, and those cases have gone to the apex court also. Some rulings were also quoted and cited. What the Constitution says, that's one. How it has been interpreted by the judiciary, another, and what has happened in the previous cases also.
Thank you. This is not the first time, as you rightly mentioned, Vishal, that the court is being faced with questions like this. Advocate Sangla has very eloquently laid out the history and the background of the anti-defection law. I'm going to dwell upon the fact as to what does the legislature's procedure talks about in terms of when it comes to defection proceedings. So in every legislature, there's a rule book, and the rule book talks about the precedence of business. And if you look at the Maharashtra Legislature's rule book and the directions issued by the Speaker of the Maharashtra Legislative Assembly, it lists down every single aspect. So, for example, one of the first things that takes precedence in terms of business in the Vidhan Sabha is if a MLA has to take an oath as a member of the Vidhan Sabha. Now, in that sequence of precedence of business that has to be transacted in the Vidhan Sabha, the business that comes before a no confidence motion is the business of if there is a motion for the removal of the Speaker or the Deputy Speaker. And right after that, the rule book, the directions of the Speaker mentions that after the motion of discussion and removal of a Speaker takes place, then the motion for confidence in the government can take place. Now, the reason I'm mentioning this is because one of the arguments that is being talked about is you mentioned as to what takes precedence. So the rule book makes it clear as to, in terms of proceedings within the Vidhan Sabha, what will take precedence. Removal of the Speaker, if there is a motion for that, that will come first, and after that, the confidence motion will come. Now, the disqualification proceedings of MLAs, or whether the 2/3 of the MLAs constitute a separate faction, are they merging with somebody, are they not merging with somebody? Now, that is not part of the legislature's proceedings. That is a process that is to be held before the Speaker. So it does not happen on the floor of the House. So those two things don't have to go into one continuous sequence. And this is something that the Supreme Court has held on multiple occasions. So, for example, in a roughly similar situation in 2020, in Madhya Pradesh, a number of MLAs had resigned before the floor test. The question was, can the resignation of the MLAs before the floor test, is it necessary that the Speaker determines that question first before the floor test happens? And the court said, no, that's not the case. So, when we are discussing the events in Maharashtra, we have to de-link about things that are going to happen on the floor of the legislature and things that are going to be adjudicated by the Deputy Speaker, because the Speaker's position is currently vacant in Maharashtra. One final thought on this subject. Now, this is not the first time that a motion or a notice has been given for the removal of the speaker or the deputy speaker. When there was political turmoil in Arunachal Pradesh in 2015, there were rival factions of the political party. One faction of the party, gave a motion for the removal of the speaker. And in that particular case, the Supreme Court held that, if there is a motion pending for the removal of the speaker, can the speaker actually go ahead and decide on the disqualification proceedings?
Okay.
And the Supreme Court interpreted the Constitution to say that the relevant article of the Constitution of India actually explicitly says that all members of the Legislative Assembly will participate in the removal of the speaker, in the discussion of the removal of the speaker. And therefore it held that the removal of the speaker, if MLAs cannot participate in it because they are being disqualified or, their vote is not going to be counted, that's not the way it is going to happen. So that, and that was a constitutional bench of the Supreme Court. So that kind of makes it clear as to what we can possibly expect from the Supreme Court's judgment that's going to happen in about half an hour.
Okay. So basically, within the legislature, the process is pretty much clear, as Chakshu is pointing out, Advocate Sankla, that these two aspects are pretty much delinked. Disqualification proceedings to be looked at by the Speaker is an entirely different procedure. Of course, it doesn't happen on the floor of the House. And on the floor of the House, in terms of what takes precedence, is if any motion is moved against the Speaker or Deputy Speaker who is presiding in his stead, that would take precedence over the confidence motion. That aspect, we'll come to that as well. But let's, since Mr. Sanjay Jog is also with us, joining us from Mumbai, let's also look into the political, movement which is happening on the ground there, and that also gives a lot of indication there, Mr. Jog. A cabinet, meeting which was chaired by the Chief Minister there. Quite a lot of decisions being taken, but most important part, the Chief Minister reportedly mentioning in the cabinet meeting that it has been a worthwhile tenure of 2.5 years. Everybody has, supported us except some of my own party MLAs. Is that some sort of indication what is likely to happen in the hours to come?
Absolutely, Vishal. What has, Mr. Thackeray is that way a very sensible and an emotional guy. He spoke to basically the NCP and the Congress allies, claiming that, first of all, thank you for your cooperation for last 2.5 years. But most importantly, he came out with a strong word, saying that my own party men betrayed me, ditched me. I think that is, that's how his self came out, And the second thing what he said is that in the last 2.5 years, the government has tried to do a major developmental work, handling the corona effectively, which has been held worldwide. And the third, what he said is that despite the coalition government, on most of the issues, three parties remain together. For example, today, the two major contentious decisions were taken. A, renaming of our Maharashtra's tourism capital, Aurangabad, as Sambhajinagar, and the adjoining district, Usmanabad, as Dharashiv. Just to tell you that Congress and NCP have never been comfortable with these decisions. But as tomorrow, there is a floor test which is lined up. Both of them, it seems, have yielded, and they have just given their go-ahead. So just putting it the facts together, Mr. Thackeray, it seems, have indicated that even though he said that he is ready to continue his fight, both the legal and on the floor of the House, but at the same time, the sources tell me that if the Supreme Court judgment goes, in favor of governor asking him to, approve a majority tomorrow, then the Shiv Sena insiders are saying that he may step down. But for that, we'll have to wait for next 1.5 hours.
Okay. Yeah, that is another, political aspect there. And it looks like what Mr. Jog is referring to through his sources, that the Chief Minister might throw in his towel, depending upon what the Supreme Court says. But coming back to, the constitutional aspect and the legislative aspect as well. Now, since these two things, as Chakshu was pointing out, Advocate Sankla, that these two things are clearly defined apart. So, in this case, it is also has been reported that, a notice has been moved against the Deputy Speaker also. So if that's the case and that is being admitted, that takes precedence over the floor test as well.
Well, imagine this, that if the House has lost confidence in either the CM or in the Deputy Speaker, would or should they be permitted to continue or to pass an order that is detrimental to the House itself? I mean, that is the question that was asked time and again. And I'll tell you something very interesting. There's an exceptional argument in this case where each and every party relied on one judgment, which is called the Rabia judgment. Every lawyer today relied on Rabia judgment and sought its own interpretation. Now, Rabia is a 2016 judgment where around 20 MLAs of the Congress defected, were rebels. They showed their displeasure with the government and the CM and the Speaker, the Deputy Speaker, and questions arose which were twofold and which are also happening here. One, the governor stepped in and the governor expedited the assembly, gave a date which was questioned by the Deputy Speaker. At the same time, an application was moved showing their displeasure and no confidence and non-continuation of the Deputy Speaker. In retaliation, the Deputy Speaker moved an application or moved an order for disqualification of the rebel MLAs. This went to the High Court. The High Court gave an order in favor of the MLAs. This was thereafter challenged in the Honorable Supreme Court, and therein came the holy troika of 3 articles. Article 163, Article 174 and Article 179. Article 163 and 174 pertain to the governor. Article 175 pertain to the powers, rights and obligations and the liabilities of the Deputy Speaker. And what was held is very interesting because it is also something which has been argued here today. Does the governor have the power to expedite the assembly? The Honorable Supreme Court said no and gave a reason why. 174 said, does the governor have the power to say that the House falls? The Honorable Supreme Court said no again. Why? Because they said that he had to move under the ambit of Article 163, which is take into confidence and take into consideration the advice of the ministers and the CM. But there was an exception. And the exception was this, where the House itself does not have the confidence. And therefore, under those circumstances, or where is a law and order situation, under those circumstances, the governor can apply his own mind.
Okay.
But in that particular case, came against the governor. The second aspect was whether the move of the Deputy Speaker in asking the rebels that you are disqualified was correct or not when there was a challenge to his power. The Honorable Supreme Court said no, you should have waited because the House does not have confidence in you. And that is exactly what has been argued today.
That's interesting, Chakshu, because, you know, this troika of articles which Advocate Sakla is mentioning takes into consideration the role and the responsibility and the limitations of all the constitutional functionaries involved here, the governor, the speaker and the deputy speaker as well.
Yeah, Vishal, I think an important aspect that possibly we will get argued today is what is the discretion of the governor in calling for the floor test.
Okay.
Now, Advocate Sakla was referring to the 2016 Constitutional Judge Bench, which dealt with some of these issues. I would want to take you a little further back when the Constitution was actually getting made. And during the debate on the Constitution, on the powers of the governor, our Constituent Assembly was very clear that the governor had very limited powers. So the Assembly, in its discussions and deliberations, basically said that the governor always had to act on the aid and advice of the Council of Ministers. And B.R. Ambedkar, the architect of the Constitution, gave 3 exceptions as to when the governor could exercise his own judgment. Now, the first exception was in choosing the chief minister after a general election has been held. And that, seems to be pretty obvious because there is no chief minister to aid and advise. So after a general election, the governor exercises the choice on who should become the chief minister. The second exception was that if there is a breakdown of law and order, then the governor can recommend to the president to impose president's rule in the state.
Okay.
Now, this was also explained by saying that in this particular aspect, possibly the state government will not reach out to the governor and say that, under our governance, law and order has broken down. So please recommend president's rule. So in this particular aspect, the president also has discretion. The final thing that the Constituent Assembly said that the governor has discretion on is because in a situation, the Constitution says that the Council of Ministers holds office as long as it has majority in the legislature.
Mm-hmm.
Now, imagine a situation where the Council of Ministers does not have a majority and does not recommend to the governor to call for a session of the assembly.
Okay.
So B.R. Ambedkar said that if a government which does not hold the majority should not cling to power by not convening the legislative assembly.
Okay.
So the third exception is that in case the government loses majority, the governor, can direct the assembly to convene and order for a floor test. And this is exactly what has happened in the past.
Okay. So all these nuances will, of course, be clear when the Supreme Court comes out with the judgment. But going back to Sanjay ji, on the ground, if we have to understand, of course, whatever the Supreme Court judgment comes in, and if the floor test is taking place on 30th of June at 11 a.m., two, three things which we would like to understand, and viewers would also like to understand is, one, since Eknath Shinde group is claiming that they are the real Shiv Sena, that's one aspect. Does it look like that's the line which Eknath Shinde and his, other rebel MLAs are going to toe? And also, in terms of numbers game, when we are looking within the assembly, how do you look at the assessment? The government trying to, of course, ensure that it wins the majority, but is that possible?
Vishal, let me tell you as the figures that you mentioned earlier. Shiv Sena has got 55 out of it. Eknath Shinde has been claiming 39. So 16 remain with the Thackeray-led Shiv Sena. Then NCP, the second most important ally. They have got 53, but I am not sure whether Nawab Malik and Anil Deshmukh will be able to cast their vote.
Okay.
So they may have 51. Then third come Congress, they are 44. Along with that, earlier they used to claim they have a support of two Samajwadi Party and also two Prahar Janashakti, which has sided with now Rebel Shinde group. Apart from that, they used to claim support of 13 independent and smaller parties. But again, Shinde camp is saying that they have got almost lured 9 independent. So this is the reality. So that comes to about, say, 116 to 120. Now take the side of BJP. BJP on its own has got 106 plus 2 Prahar Janshakti of Bachchu Kadu. Then, apart from that, they have got 7 independent and smaller parties. Today, Raj Thackeray has extended a support. And apart from that, the 9 MLAs who have sided with Rebel Shinde group may also extend their support. So, all in all, there will be a tussle between the two. And the number is going to be very interesting. Earlier, just to take you back, Vishal, MVA always used to claim that they have got a support of total 169. Now, let us see now, if at all you put together the rebels together, the BJP and rebels and all those smaller and independent comes to almost 163, which is almost 20 plus for the halfway majority mark of 144. So let's wait and see what happens tomorrow on the floor of the House.
Okay. Indeed, that is going to be interesting, whether the Thackeray government wins the trust vote, if the trust vote takes place on 30th of June at 11 o'clock. And in that scenario, how will it pan out? We'll keep on bringing you all the details. Thank you so much, Mr. Sanjay Jog, Mr. Chakshu Roy, and Advocate Kapil Sankla as well for sharing your views and insights. So that's all about what's right now happening in the state of Maharashtra with the political crisis. Quite interesting developments, lots of twists and turns as it happens in political situations like these. And of course, the ball rests in the Supreme Court's court as of now. And the final decision by the court is likely to come at 9 p.m., depending on which the floor test will take place or will not take place on 30th of June. We'll keep you updated on all the developments in our news bulletins and other shows as well. Keep watching Sansad Television. Thank you.